Welcome once again to Lehto's Law. Here's Steve Lehto.
I've done stories before about people who weren't attorneys pretending to be attorneys. And oftentimes it's people who went to law school but just didn't pass the bar. You know, that little technicality at the end there. And so when this story hit the news, Paul spotted it and passed it along to me. But, you know, this is an interesting story as well. Fake lawyer represents himself unsuccessfully in marathon hearing. And this story is by Jonah Meadows, and it's out of Illinois. An admitted identity thief and fake attorney facing charges in Illinois and Florida unsuccessfully represented himself in a probation violation hearing that took more than 6 weeks to complete. After John Ryan rejected a plea deal, a Lake County judge found him guilty of failure to report to his probation officer, and he now faces several years in state prison as well as pending charges in Cook County and Miami-Dade County. So, you know, they say that if a lawyer represents himself, he's got a fool for a client. I'm not sure what happens when a fake lawyer represents himself. But Ryan, who has past addresses listed in Chicago, Evanston, Lockport, Mount Prospect, and Skokie, would have been due to complete his probation this month following his May 2017 guilty plea to 1 count of identity theft. Instead, he's due to be sentenced in January before becoming eligible to face charges in other jurisdictions. This is a mess. Prosecutors had agreed to drop additional counts related to thousands of dollars in bills he allegedly racked up at Deerfield hotels, pretending to be a U.S. Senate candidate and attorney while dodging a warrant for his arrest from Wisconsin, where he was wanted for violating the terms of probation resulting from a conviction for escaping arrest. This guy's resume is fascinating. Nothing else, but it's fascinating. He was shipped off to Dodge Correctional Institution in Wisconsin with instructions to report back to Waukegan as soon as he was released, according to testimony at his probation violation hearing. He was released August 18th, 2018, but instead of serving his probation and setting up a payment plan for the restitution he owed, he headed to South Florida within a few months and established a new fake law firm called Harding and Pierce. It's according to reports on Patch, which is, of course, the internet news service. Past Illinois ventures that Ryan founded or operated, including a law firm called Berkshire and Ross. These are great sounding names, you know. Too bad they're not real. And moving companies named MoveWire, U.S. Logistics, and Allied North America, according to police reports and state records. His companies faced allegations he would collect payment up front, never deliver items or render services, and he is alleged to have taken settlement money when he was able to convince insurance companies he was an actual attorney. I know real attorneys who can't get money out of insurance companies, so there's something strange going on here. One client who hired him as a lawyer to collect unpaid debts to a construction company told investigators that the man had managed to successfully collect 9 out of 10 debts, but they became suspicious of him when he failed to perform a simple contract agreement. His business model usually involved an answering service, office space he shared with somebody, and plenty of puffery, which apparently he was good at. So it goes on here. He would soon get a chance to practice law in a real courtroom for the first time. Lake County Circuit Judge Patricia Fix presided over a 4-part hearing on a petition by prosecutors to revoke Ryan's probation, which they filed in December of 2018 after learning that Ryan never showed up after his release from jail in Wisconsin. Ryan was initially represented in the process by a public defender who received a plea offer of 4 years in prison. That would have amounted to about 19 and a half months, accounting for good time and all that, good behavior. But the unlicensed lawyer decided to dismiss the offer, fire the court-appointed attorney, and represent himself. He was told, be that as it may, you are legally allowed to represent yourself pro se if that's what you'd like to do. But of course, otherwise, you can't be a fake attorney. But representing yourself, you can. You're always allowed to represent yourself. So before allowing the man to waive his right to counsel, the court asked him a series of questions. And he told the court he dropped out of college in Wisconsin and had never gone to law school. So, you know, it kind of shoots a hole in the theory that he's got a law firm that he runs. The judge warned him that the assistant state's attorney, Danielle Pasucci, who would be soon prosecuting what she described as the longest hearing on a petition to revoke probation in her career, had more than 20 years of experience. She had early gotten the court to explain that one of the other people had been involved in more than 1,000 such hearings in 13 years of experience in criminal defense. So, guy insisted, represent himself. So the court told him, they both have law degrees and you don't. Even though you have had a contact in various legal proceedings, the fact that you are unfamiliar with representing yourself in a criminal case puts you at a disadvantage. And the courts will always do this. If you want to represent yourself, they'll let you, but they'll usually give you that stern warning, that lecture beforehand, so that later on you can't say, hey, I didn't have an attorney. Incompetent counsel. Malpractice. Lock up my bad attorney. Oh, wait, you already did. The judge allowed him to act as his own attorney and gave him about an hour to prepare for the hearing, but he had requested more time. The court reminded him that he'd had plenty of time to prepare for the hearing. It's just that when he fired his attorney, it kind of threw the monkey wrench in the plans. Later that day, the prosecution called only two witnesses. One was a person who worked at probation services. The other was a court clerk. They testified about the details of the probation agreement the man had signed before his release from Lake County Jail and explained that the clerk's records showed the only restitution ever paid of the $8,500 that was owed was the nearly $2,300 in cash that the police had confiscated from him at the time of his arrest. Ryan objected repeatedly during the proceedings, and some of them were sustained. That's good. His cross-examination is focused mainly on the fact that he was not properly provided a paper copy of the requirements of his probation, and that the deadline for payment of restitution had not yet passed when prosecutors petitioned to revoke his probation. Ryan asked one of the witnesses if the defendant had ever been given a schedule for paying back the money owed, and she pointed out that he had never showed up to get one. You and I would have gone over a payment plan once you came into my office, she told him and the court. After the people rested their case, which only needed to be proven to the preponderance of evidence standard, he announced he wanted to call as a witness his former public defender, two corrections officers, and a woman who lived at his last known address. Ryan argued their testimony would show that he was never mailed instructions to fulfill the terms of his probation, and that the sheriff's office had destroyed them. He suggested his lawyer could testify that he had offered to pay restitution. So the court actually let him get an extension of time to bring in his witnesses. He also filed a handwritten motion seeking to dismiss the case, and made a bunch of other arguments, but case proceeded. On October 17th, the second day of the hearing, Ryan filed his motion, told the judge it would violate an unbroken and unabrogated line of cases if he were to found to violate his probation. He said he'd been unable to file necessary subpoenas from within the jail, where he had no access to internet and little access to the law library. The judge asked about the jail's iPad program and was told they do not connect the internet or the clerk's website. Fix, that's the judge, then granted a motion to issue subpoenas and set a date for another hearing in 3 weeks. So the guy got some of his delays and adjournments and so on and so forth. So as it went along, he got these hearings delayed and adjourned, and they finally got to closing arguments, during which the prosecutor emphasized that Ryan never made any attempt to pay restitution or to abide by the terms of his probation following his release from prison. Did not matter, she argued, whether the probation instructions were transported with him to Wisconsin. But there was no testimony it wasn't brought, she said, or that the defendant had some mental illness that would cause him to forget that he's on probation. In his closing argument, Ryan said the state had failed woefully to prove a willful violation of probation. The burden of providing instructions and directions was on the probation officer, he said, asking for his probation to be reinstated. The judge disagreed. The probation department did not move. We're all still here, and the burden was on you. The judge cited unrebutted evidence that Ryan knew he was on probation and never made any effort to contact Lake County authorities about it. She then found him guilty of failing to report by a preponderance of the evidence. I'm not even going to address the willfulness when it comes to allegation he failed to make restitution payments, she said. She ordered Ryan to remain held at Lake County Jail in lieu of a $100,000 cash portion of his bond ahead of a January 16th sentencing hearing. It's likely he will face no more than 6 months of additional prison time as a result of his decision to reject the plea offer and represent himself through the multi-part hearing. With outstanding warrants from Rosemont and Miami, it is not clear where Ryan may face charges next. The other jurisdictions will have to get in different parts of the line, the judge said. But again, it's the headline. I think that's really the pure comedy gold here. Fake lawyer represents himself unsuccessfully. So that's Paul passing that along. Jonah Meadows wrote the story. It's actually much longer than that, but it's a fascinating topsy-turvy ball of confusion caused by, like I said, the fake lawyer who wants to represent himself and fires the lawyer that the court would have provided to him if he had wanted to have actual representation. So there you go. And thank you for the stories. Keep them coming. Anything that you think might be interesting, pass it along. Once in a while, I get a bunch of them. Once in a while, I only get one. So, Paul, thank you very much. Questions or comments, put them below. Otherwise, I'll talk to you later. Bye-bye.
Thanks for watching Lehto's Law. Robot Lady needs a new pair of shoes.